as the term defined resolution, that is a very important aspect of the company meetings. Resolution has to be passed in board meetings of the company or annual general meetings of the company or any other important emergent meetings of the company. Board resolution has to be passed in company meetings. And it is a legally binding agreement and decisions made by the company, by the members of the company, by the directors of the company. So resolution has to be passed in the board meetings of the company, and that makes that resolution valid. That makes it a valid resolution to be applicable to all members of the company, to be compiled with the rules and regulation in respect to that resolution. So it is a legally binding agreement or decisions made by company members or directors of the company. For every decision in the company meetings, it has to be passed by resolution, whether ordinary by nature or special by nature. The resolution has to be passed among the members of the company to get it a final conclusion on that particular matter which we discussed in the meeting, and for that resolution has to be passed with respect to the majority of the members are in favor of the resolution or against the resolution. So outcome of resolution is determined by the vote cast for and against the decisions. If the required majority is reached, the resolution is to be passed, and it is necessary that majority is not reached. The resolution has supposed to be, it is not able to pass, and it is failed. So that is you can say any decision of the company taken in the company meetings. Company cannot take decision on its own. So company depends upon the resolution to be passed, has to wait for the resolution to be passed in the meetings by the members or by the persons who present in the meeting, either in person or in proxy. If the majority of the shareholders they are in favor of that resolution and it is passed in the meeting, otherwise it is failed to pass in the meeting. And so at least 1/3 of the majority, at least 1/3 of the member should be in favor of the resolution passed in the company meetings. Then there are different types of resolution. Resolutions. Any decisions made by directors of the company is called resolution. But there are two types of members resolution. That is, one is already discussed. I have already discussed with you about ordinary resolution and special resolution. So any decisions taken by the company in respect of the any agenda, any item that is mentioned in the agenda of the meetings of the company, and that item must be discussed with the members of the company, shareholders of the company, and any decisions to be passed either by ordinary resolution or by special resolution. And ordinary resolution is passed where simple majority vote is reached above 50%, then that case ordinary resolution is passed. And when we meet 70% of the person should be in favor of the proposed matter in the meeting, in that case a special resolution is passed. When a 75% majority is reached for a particular proposal in the meeting, which is to be passed to obtain that special resolution. And this resolution can be used for all decisions unless the Companies Act and the Articles of Association of the company specifies the need for a special resolution for any other matter that is not mentioned in the minutes of, in the notice of the meeting. That matter to be discussed with the permission of the chairman in the meeting, and with the permission of the members also that present in the meeting to discuss any other item in the agenda under the head any other matter to be discussed. That to be discussed in the meeting, but for special matters to be discussed in the meeting, we need some special resolution to be passed in order to obtain the majority towards that particular resolution, that particular proposal. Then types of resolution. There are both types of resolution which we have already discussed, ordinary, special, and these resolution can be passed at a general meeting or in writing. A written resolution apart from resolution to dismiss a director. These are the resolution to be passed for the removal of director, for the dismissal of director, for the appointment of auditor, for the reappointment of auditor, for the reappointment of directors of the company, for the appointments of any other officer of the company, licensed officer of the company, any other important officers of the company, chartered accountants of the company, so independent directors of the company. So any other very important matter to be discussed, for that we need to pass a resolution in the meeting. A company cannot take decision on its own in regard to the appointments of the directors of the company. So company needs other persons, the members of the company, to discuss in regard to the appointment, their dismissal, their removal, in respect of their disqualification, to be again reappointed as director of the company. So we have to pass resolution at a general meeting in writing. It must be in writing. A written resolution must be there so that it can be signed by the members of the who are present in the meeting in person, or either in proxy. That person can sign the minutes of the general meetings to make that decision valid in the meeting in regard to the resolution to be passed for the purpose of enforcement of that resolution after it is passed among the members, it is signed by the members of the company, and it is attached to the commences of the company, and that makes a binding agreement between that person and the company that your appointment is approved by the members of the company at the general meeting of the company. So that makes your appointment valid, and it is you can present in the court of law in the case of any discrepancy, any controversy, or any type of dispute is there. You can present a document in the court of law as a valid documentary evidence. So these are the matters to be for which we need a resolution, which is mentioned in this slide. Dismissal of the director of the company, removal of auditors of the company, and before the expiry of his contract terms of contract with the company, and if a member is unable to attend general meetings, he or she can appoint a proxy. So unless until it is authorized to you by the articles of the company for the appointment of proxy, otherwise you have to present in person, otherwise the absentees is there, you are absent from the meetings. So both type of resolutions can be passed at a general meeting, either in writing, a written resolution apart from resolution to dismiss a director and removal of auditors of the company before expiration of his or her contract, and if a member is unable to attend general meetings, he or she can appoint a proxy. So, but you can appoint a proxy if AOA authorizes you to appointment of proxy. Otherwise, you cannot appoint a proxy on your behalf. It must be authorized by the company for the purpose of appointment of proxy. So these are the issues. Can be passed at general meetings in writing. Resolution must be in writing so that it can be read by the members of the company, discussed at the meeting, and come to a conclusion whether to accept that resolution or to reject that resolution in the meeting. And if it is accepted, it is passed in the meeting. Otherwise, it is not passed. It is declared not accepted in the meeting. It is a failure to accept the resolution mentioned in the to be discussed in the meetings of the company. So board type resolution have to be passed. Ordinary resolution is a resolution passed by a simple majority of votes, as provided in subsection 1 of section 114. A resolution shall be an ordinary resolution if notice of such resolution is duly given and the votes cast in favor of the resolution exceeds the vote cast against the resolution, if any. So ordinary resolution is resolution passed by simple majority of votes as provided in subsection 1 of section 114. This is as given Companies Act 2013, section 1, subsection 114, section 114 of subsection 1. It can be passed by a simple majority of votes as per this section. So a notice of such resolution is duly given and vote cast in favor of the resolution exceeds the vote cast against the resolution, if any. Meaning is that the resolution means the matter to be discussed in the meeting. What you discuss, meaning is that what you discuss in the meeting, in the general meetings of the company, what matter you discuss, what agenda you discuss, and what items you discuss in the meeting. And that items must be passed in the meeting, otherwise it is rejected on the grounds of certain grounds. And that ground must be genuine enough for the purpose of rejection. Why it is rejected, why your appointment and reappointment and removal from place of office is rejected, on which ground it is rejected. For that purposes we are doing voting. Right is there for the shareholders, so shareholders can cast their votes in favor of or in against of the resolution. It is their voting rights as a shareholder of the company, as a member of the company. It is your voting rights to cast vote against the resolution of the company. So this is as per section 114 subsection 1. This is a type of resolution passed by simple majority of votes. Those who are in favor, if it is exceeds those who are against the resolution, in that case the last voting of the chairman is very important. His or her yes or no, his or her vote in favor or against is very important to decide whether the ordinary resolution is passed in the meeting or not, or it is rejected on this ground, it is not accepted by this number of votes. The chairman vote is very important. The last and final vote of the chairman who chairs the meeting, whether it is annual general meetings of the company or extraordinary general meetings of the company, chairman of the meeting is very important. Chairman starts the meeting, indulge in deliberations in the meeting, discussions in the meeting, and he is a person responsible to end the meeting with vote of thanks to the members present in the meeting. So his or her vote as chairman of the meeting is very important for the purpose of passing resolution as ordinary resolution. So the method of voting might be through by show of hands, electronic voting, by poll, or any other permitted methods, or a postal ballot. So the number of votes of only the members who are entitled and voting are to be counted. So the method of voting must be through by show of hands or by electronic voting polling or any other permitted methods or postal ballot. The number of votes of only the members who are entitled and voting are to be counted. Means number of valid votes to be counted who are those who are the members of the company. Only they are entitled to vote into the meeting, and their voting is to be counted. Those who are not members of the company, they are not entitled to vote in the annual general meetings of the company for the purpose of passing resolutions in the meetings of the company. So methods of voting might be by showing of hands, raising of hands, or by electronic voting is there, polling is there, or any other permitted method which is allowed to as per the Companies Act to vote, or by postal ballot is there if members they are not able to present in person, or because of the low attendance in the meetings of the company. In that case, company can pass a resolution by postal ballot system. The company has to send ballot papers by the use of postal mediums to the members of the company. Hence, the person who abstain from voting are not allowed to vote, whether under the provisions of this Act or otherwise, and are not to be counted. So those who are abstained from voting, those who have no right to vote into the annual general meetings of the company or meetings of the company, they are abstained from voting, are not allowed to vote because their name is not mentioned in the register of members, and your name is removed from the register of members of the company. In that case, you are not allowed to vote in the meetings of the company. So members who abstain from voting are not allowed to vote as per the provisions of the Companies Act 2013, and their vote is not to be counted for the purpose of counting of votes, for the purpose of passing a resolution, ordinary resolution. Then special resolution is there, and for the purpose of passing a special resolution, the essential requirements are: number one, intention to propose the resolution as a special resolution has been duly specified in a notice. Meaning is that for any passing of any resolution, whether it is ordinary by nature or special by nature, we have to notify to the members of the company by issuing a notice to the members of the company or shareholders of the company that we are going to propose this resolution in the annual general meeting of the company held on this date, particular time, day and date, place of the meeting to be mentioned in the notice of the meeting. And so intention to propose should be duly notified by issuing a notice to the members of the company, or you can say shareholders of the company. Then point number B, notice required under the Act has been given. So it has been given. You have to, this is as per the Companies Act 2013, whatever notice you are issued in respect of the passing resolution to the members of the company, that notice has to be given to the members, and keep a copy of that with the company and submit one copy to the ROC of the company for the record purposes. Point number C is vote cast in favor of the resolution are not less than 3 times the number of votes, if any, cast against the resolution by members. So in other words, the vote casting should not be less than 3 times the number of votes, if any, cast against the resolution by members. In other words, resolution is carried out with 75% of the valid votes should be in the favor of the resolution. Means 75% of the majority should support the resolution to be passed in the annual general meeting or extraordinary general meetings of the company. That resolution is called as a special resolution. It means that 75% of the people of the is in favor of the resolution, and the vote cast in favor of the resolution are not less than 3 times the number of votes, if any, cast against the resolution by members. Other types of resolution, the provisions of the Act require passing of resolution which have certain different compliances, and the example of such resolution is subsection 6 of section 230 of the Act for approving the scheme of compromise arrangement is there. If we are not able to get the adequate majority for the purpose of passing resolution in the company, in that case we have to make a separate arrangement for the passing of resolutions, and that arrangement is called as compromise arrangement. Compromise is there, so because we have to make arrangement, we have to make settlements of the resolutions and all. So and this type of resolution is called as the compromise arrangement as per section 230 subsection 6 of the Companies Act 2013. If persons are not in favor and not in support, in that case a problem arises. If the number of persons who are in favor is less than the number of persons who are against, in that case we have to make some arrangements, and that arrangement is called as a compromise arrangement. The said resolution is called as the compromise. Other types of resolution that is come under the category of compromise arrangement, and this requires the approval of the majority of person representing 3/4 in value of shares. That is required in the case of compromise arrangement as per section 230 of the subsection 6 of the Companies Act 2013. Then circulation of resolution, meaning is that whatever you are discussing in the company meetings, you have to circulate that among the members to be passed in the meeting. Circulation is there. So resolution is to be proposed to be passed shall be circulated and in the form of a draft among the members of the company, directors of the company, committee members, along with explanatory note in details stating the business to be conducted in that particular annual general meetings of the company or extraordinary general meetings of the company. So whatever you are discussing in the meeting, for that you have to pass a resolution to that effect, and for that purpose you have to circulate the copy of the resolution, circulate the copy of the item to be discussed in the meeting, business to be transacted in the meeting, along with the explanatory notes among the members of the company, directors of the company, members, subscribers to a member of the company, members of the company, shareholders of the company, to be discussed at the company meetings. So it must be circulated, it must be passed among the members, so that members have information in respect of the passing of this item number 1, item number 1, item number 2 in the meeting. And if it is passed, it means a resolution is to be passed in the meeting for the appointment, for the reappointment purpose, for the removal purpose, for extension plan, diversification plans of the company, discontinuation of the company, winding up of the company. These matter to be discussed and passed at the meetings of the company. Then according to section 175 of the Companies Act 2013, no resolution shall deem to be have been duly passed by the board or by a committee thereof by circulation, unless the resolution has been circulated in the draft together with the necessary papers, if any, to all the directors or members of the committee. So as per section 175 of the Companies Act 2013, point number 1, no resolution shall be deemed to have been duly passed by the board or by committee by circulation, unless the resolution has been circulated in the form of draft. So without circulation in the form of draft, along with the necessary documentary evidences, necessary papers as required for the information purposes among the members of the company, among the directors of the company, if it is not circulated, how can it be passed? So without circulation, it cannot be passed. First, you have to circulate it among the members, the item to be discussed in the meeting, the agenda to be discussed into the meeting, and then it is passed after discussion, after deliberation in the meetings among the members. Then we decide to conclude it is passed or not passed in the meeting. First, you have to notify, inform to the members of the company, directors of the company in respect of this type of resolution to be passed in the meeting. It is supposed to be passed in the meeting and given for circulated among the members, the copy circulated among the members along with the necessary documentary evidence, working note is there, copy of the bill is there, explanatory note is there. So you have to notify this to this effect among all the members of the company, so that they have information in respect of this item to be discussed and deliberated in the meetings, and there should be a voting process in the meeting to pass resolution in the meetings of the company. Then, as the case may be, at the registered office of the company, by hand, you can circulate by hand delivery, or by post delivery, or by courier, or by electronic means as we prescribed, or as approved by the majority of directors or members who are entitled to vote on the resolution. So the copy of the resolution to be passed in the meeting, proposed to be passed in the meeting, along with the necessary documents and papers, must be provided to the members of the company, either provided by postal delivery, or by courier, or by hand, or electronically. You provide by mail. You can provide information through by mails, official mails. You can provide information to the members of the company in respect of the item to be discussed, transaction to be discussed in the meetings of the company. It should be informed first, then we can discuss in the meeting, because the members come prepared accordingly. This item will be discussed in the meeting, they or make a preparation for that discussion before meeting, so that it can be discussed and deliberated in a better manner. Otherwise, without information you are coming, without preparation you are coming for the meeting, without knowledge that this item to be discussed in the meeting, how can you give your better output into the meeting? So you should have first information about this matter to be passed in the meeting, and with proper information, with proper documents, then you can go for the process of passing of this in the meetings of the company. Then there are certain restrictions are there, where not less than 1/3 of the total number of directors of the company for the time being require that any resolution under circulation must be decided at the meetings of the company. So whether it is annual general meetings of the company, or other general meetings of the company, or extraordinary general meetings of the company, where not less than 1/3 of the total number of directors. Suppose there are 10 directors in the company, so 1/3 of 10 directors, at least 3 directors of the company for the time being required that any resolution under circulation must be decided at a meeting, and the chairperson shall put the resolution to be decided at a meeting of the board. first you have to place, meaning is that first you have to place your agenda, your item to be transacted in the meeting before the in the company meetings, so before the members of the company, and then you can discuss. Okay, so we are not less than 1/3 of the total number of directors of the company. By time being required that any resolution under circulation must be decided at a meeting. Must be. So, meaning is that if you want to circulate any resolution, it first has to be decided that it has to be circulated among the members of the committee, then only it is circulated. So without approval, the resolution or item to be discussed in the meeting or transaction to be discussed in the meeting cannot be circulated without the permission of the chairperson, you can say, without the permission of the directors of the company. It cannot be put resolution among the members of the company to be discussed at the meetings of the company. Then minutes of meetings. Companies Act 2013 defines minutes of the meetings as a record containing the proceedings of a meeting, and we have minutes of the meeting is very important documentary evidence, very important from point of view that what we are discussing in the meeting, why this meeting has been conducted, what are the points, deliberation points in the meeting, what conclusion we arrived at the meeting. So minutes of the meeting provide detailed information about the meetings, items, transactions, business transactions to be discussed in the meeting, or any other matter that is not mentioned above in the notice of the meeting. That matter can be discussed in the meeting, and under the head any other matter to be discussed in the meeting. So minutes of the meeting is very important document, part of the company meetings. A minute has to be prepared, has to be submitted before the register of companies. A copy to be retained with the company, one copy with the company, and another copy to be kept for record purposes at the ROC of the company. So minutes of the meeting make your appointments, make your resolutions valid. Otherwise, if there is no minutes of the meeting where you discuss this item, because this is a public limited company, public money is invested, public they are investors of the company, financiers of the company. So public should know what you are discussing in the meeting and what conclusions you arrive at the meeting after discussions, after deliberations in the meeting. So minutes of the meeting provide you very important information about the matters to be discussed in the meeting, what happens inside the meeting, who are present in the meeting, the members present in the meeting, who are absent for the meeting. So you have information about each and everything that is mentioned in the minutes of the meeting. The members who are present in the meeting, their attendance is mentioned in the minutes of the meeting. Those who are absent for the meeting, that is also mentioned in the minutes of the meeting. So minutes of the meetings are prepared by company secretary or any other person authorized by the board of directors of the company. So minutes means written record of the proceedings of a meeting. What happened? Proceedings means either your video recording is there, you record your meeting and make a video of your meeting. So recording is there, video recording is there. You can make a recording of video recording of the proceedings of the meeting that for the purpose of record, or you can make a written record what you are discussing in the meeting by making reporters are there, so they are sitting in the meetings and they record the proceedings of the meeting. Company secretaries are there, chartered accountants are there, so they are recording the minutes of the meeting. So minutes means a written record of proceedings of a meeting, and it is evidence of the correct record of the decisions of a meeting as per section 118 provides the rules regarding the recording of the minutes as per section 118 of the Companies Act 2013 provides the rules in respect of the recording of the minutes. Just number one rule is every company shall make entry of minutes of all the proceedings of every general meeting within 30 days of the conclusion of every such meeting in bound books kept for that purpose with their pages consecutively numbered. That is a requirement, rule of law. With every company, they are officially you're bound to make follow this rule of law as per the Companies Act 2013. Every company shall make entries of minutes of all the proceedings of every general meeting within 30 days of the conclusion of every such meeting in bound books kept for that purpose with their pages consecutively numbered. It should be consecutively numbered so that we can know what are the items to be discussed point wise. We know in the meeting point number 1, point number 2, point number 3 to be discussed. So accordingly, we should have a complete information about the items to be discussed in the meeting. So make entries of all minutes for all the proceedings of the general meeting within 30 days. You have to prepare with time limit is 30 days after the conclusion of the meeting for the purpose of record purposes in bound books with their pages consecutively numbered. And each page of every such book, that is the minutes of the book, shall be initialed and signed because that makes that minutes of the meeting, records of the minutes of the meeting valid and confirmed. Otherwise, it is declared invalid because it is not signed, it is not initialed. The file is not signed, not initialed. So every page of each such book shall be initialed and signed at the last page of the recordings of the proceedings of each meeting in such book shall be dated and signed by the chairman of the same meeting. Chairman's signature is very important because that person chairs the meeting, hold a very important position in the meeting, start the deliberations in the meeting, take part in the deliberations of the meeting, and he is responsible for the conclusion of the meeting by giving vote of thanks to the members present in the meeting. So, chairman of the same meeting within a period of 30 days or in the event of death or inability of the chairman within that period by director duly authorized by the board for the purpose. So in no case the minutes of the meeting shall be attached to any such book by pasting or otherwise. You can do your attach your minutes by you are just pasting your minutes in that particular file, or otherwise you can make a other method which you have used for the purposes of recording of your proceedings of the meeting on regular basis, where you keep your records of the minutes of the meeting. For that purpose, you have to follow the guidelines of the company. In this, on that respect, you have to make a record of your minutes of the meetings, and it shall contain a fair and correct summary of the proceedings of the meetings.